The division of community property and debts is another issue in a divorce action. By definition, community property involves the acquisition of assets during the marriage. Separate property, by definition, are those items or assets acquired prior to the time of marriage, during marriage by gift or inheritance, and after the date of separation. Community property is to be divided equally. The court has the obligation statutorily to divide those assets equally between the parties. How they divide that is a subject of litigation many times. Separate property, if it can be proven or traced, is the separate property of the party that acquired that. Debts incurred during the marriage represents another issue in a dissolution. Debts that are incurred during the marriage, if those debts benefit the community, meaning the husband and wife, are subject to being divided equally between the parties. Debts that are incurred prior to the time of the marriage or after the date of separation are those that are assigned to the party that incurred that debt. A debt that was created during the marriage that did not benefit the spouse also is a debt that will not be charged to the community. Remember that the date of separation is critical in most cases. Date of separation is a date in which the parties decide they no longer wish to be married. There are generally events that occur that establish the date of separation. It is important to note that date of separation when you file your initial documents, or like the petition and the response, because the date of separation can be critical and it is often litigated. The date of separation represents the date in which the community's interest in a particular asset, such as a pension plan, will be determined. The value of residences or the value of any asset that was acquired during the marriage will be considered at the cutoff point at the time of separation, but also remember, the court will determine the value of an asset as close as practical to the time of trial. That's what the statute says. Let's go back to the debt. Debts that are incurred during the marriage, assuming that that debt benefited the community, can be twofold. One is a secured obligation. If there's a secured obligation, then the party who holds that asset will typically be charged to maintain that obligation. On the other hand, an unsecured obligation, such as a credit card, Visa, MasterCard, whatever it might be, if you have an unsecured obligation that is owing at the time of separation, that creates an issue. It depends on the party that's paying that obligation. It depends on if there's a support obligation. All of these sub-issues come into play. But I'm giving you the basics of the division of community property and debts. And again, in summary, an asset acquired during marriage, by definition, is community. An asset before marriage, after the date of separation, separate. But that, remember always, that is a principle of law that has many gray areas. I have provided you some of the basics as it relates to assets and debts, both community and separate. You cannot rely in total on what I'm telling you. The reason I gave you these background principle summaries of the issues involving the division of community property is to hopefully give you some guidance. You must rely on your attorney because every case is different. I hope this helps.